Everybody may be seated. All right. So this is 21 CF 582, State of Wisconsin versus Nya Thao. Appearances.
State by Tim Grinke and Adrian Blaze.
Nya Thao appears in person and with his lawyer, Aaron Nelson.
This is a time for sentencing. There was a pre-sentence investigation, also a number of statements from victims. I believe there were I read 5 that were submitted. First question is, has the state complied with victim notification requirements?
Yes, Your Honor, and you are live streaming this.
Yes, I am. There was a request to live stream it, so it is live streamed. I don't see anybody else on Zoom, but it is being live streamed. And do you know, is there a number of people who want to make comments today, or?
Just 2.
Just 2, okay. Were there any corrections to the pre-sentence investigation that you saw?
Not from the state, Your Honor.
Okay. And then, Attorney Nelson, were you able to review the pre-sentence investigation and the statements with Mr. Thao?
Yes, Judge, I did have an opportunity to meet with Mr. Thao, left him a copy of the pre-investigation report for him to review. We then spoke afterwards. There are 2 corrections. One is on page 19.
Let me get to that page. Okay, and where's that correction?
Within the body of that, there's a claim that he was in possession of a handgun. He denies having possession of a handgun. Agrees that there was a time when he was possessing one of the hunting guns, a shotgun, but the handgun is inaccurate as listed.
Okay.
And then on page 22, under the agent's comments, under companions, Mr. Thao denies being a member of any gang. Understand that on page 22 it says he's a suspected member. There's no listing of what the facts would be that supported or how that suspicion came to be. Frankly, I'm surprised that at this stage of a criminal proceeding that the Department of Corrections thinks it's appropriate to just put in suspicions. Now, there's lots of things here that we're going to be talking about today. I just hope that it doesn't get down to an inaccurate suspicion.
Okay. It does, yeah, it does indicate it's a suspicion. All right. Why don't we start with the statements by the individuals, and then we'll yeah, go ahead.
We do have Mr. Tao's sister does want to speak as well. So.
All right, so let's start with the individuals who want to speak.
I'm Trevor's mom. Every day I wake up, there is a missing part of me. Birthdays, holidays, getting together with family, there's a missing place. That is Trevor. That was taken too soon. Trevor touched a lot of people in different ways. The hardest thing for me is that he has 2 daughters that have to grow up without him, seeing them go through concerts, graduate, walk them down the aisle when they get married. I'm going to miss his calls. When he'd call me, instead of calling me mom, he'd call me dude, and I would correct him on that. And we were a blended family, 4 boys, 3 girls, but they loved each other like real siblings. There were 7 nieces, 1 nephew between them. Trevor got to meet most of them, didn't get to meet 3 of them because he was gone. Trevor wasn't perfect, but didn't deserve to die this brutal death. Thank you.
Thank you, ma'am.
And Your Honor, for the record, her name is Chris May, M-A-Y.
Thank you.
C-H-R-I-S. Name first.
Bridget Schlicht. I would like to tell the families of Nemo Yang Peng Lor and Trevor Maloney how sorry I am for the loss of your loved one. I don't have words for how sorry I am. I think about those 3 men daily. I hope you all can forgive me for surviving that night. I'm truly sorry. I would like to say thank you to Richard and John for believing me that day. It was truly the hardest day of my life. Thank you to Vernon County for watching over me and my family for the last 3 years. And thanks to all the other counties that participated in the investigation across Wisconsin. Thank you to the attorneys, Emily and Adrian. You two did an amazing job during this trial. One last thank you to my parents and family. I don't know where I would be without them. They've always supported me and believed me. I don't have much to say to the defendant besides that I hate you, the defendant. I hope he has a terrible life behind bars. What him and Black did is unacceptable. He took 3 young lives. Those 3 young men were someone's son, someone's brother, someone's friend, someone's boyfriend, and 2 beautiful little girls' his father. He took them away. For what? What he did to me, he made my life very hard for a long time. The last 3 years have been hard. I can actually say that it's getting better. I could go into all the stuff that I went through, but that's not your business or anyone else's. I will have to live with this memory for the rest of my life of that night. I will also have to live with survivor's guilt. I will never forgive him. And I can say that the past, this part of my past, can finally be put to rest. Thank you.
Thank you, Ms. Schlick.
So that's all the statements we had.
Okay. And then, Mr. Nelson, if you want to call, go ahead and call.
Nuchi Yang.
Yeah, if you could. That's probably the best. We'll pull that microphone down for you, okay? There we go.
Sure, it's Nouchee. Last name is Yang, Y-A-N-G. So, if I can, I have a letter that my mom wrote for my brother. If I can read it in Hmong, I did translate it in English, and I can read it in English also, if you're okay with that.
Sure. What we'll probably do is just, obviously, we'll record the English version, but if you like to do it in Hmong, that's fine.
Okay, sure. So, my mom wrote this to you, Nya Thao, the last time you were sent away, and the ending is not what she wanted, but you will hear it. It says, Lingna tu chỉ cha, có chỉ ươn you có cơ ha chu có te cô mùa lưu sư, chua nu Sunday, Lingna mong bê hở văn chữ, mà cô mùa mà cô thọ văn chữ bang của ô cho cô lưu cô mùa lưu cho lê chờ cô lưu có hình họ chính họ thọ cô cho cô lưu sa hình chế sư cho yang yếu mong tàu rong hình yếu bê cho tu chân trái văn chữ bây giờ ý chế tốt nên rong hình lê văn chữ bang của cơ tàu lưu sĩ hở cơ cú trình no. And this is translated in English. Mom's good son, your dad and I miss you so much. When I tried to utter these words out loud, tears fell down my face. Every Sunday when I go worship the Lord, I cry and beg the Lord to help you. My tears flow like a fountain. I love you so much. The important thing is for you to control your temper. That's it. Everything in life will go beautifully if everyone fears the Lord. We are a good family. I pray the Lord that you return when I am still here. When he returned this past time, my mom had already passed, so he never got to get these words from her. But I just want to let you know, Nyaku, that Mom said you come from a very good family, and you are very loved, and you will always be very loved. Thank you.
Thank you, Ms. Yang. Anybody further, Mr. Nelson?
No, Judge.
All right. The state's sentencing argument.
Your Honor, obviously the state's asking that you impose a sentence of life in prison on each of the 3 homicide counts with no ability to request an early release. I say obvious because it doesn't get much worse than this. There were 3 people that were executed from behind, premeditated, shot multiple times, shot one right after the other, and it doesn't get much worse in terms of a criminal offense than that. The court saw 2 trials. Court read the PSI, heard from the victims' families. I don't need to go over the facts in detail again. I won't spend much time on the facts of what happened and what was displayed during the trials. I would note that count 4 is possession of a firearm as a felon that was not charged as part of the crime. So at this point, the jury has found that he was in fact the person that held the gun and shot these 3 men and executed them. I don't see a lot of mitigating factors in this case. I do see aggravating factors. It's odd to say that a triple homicide could be aggravated, but I think, if anything, there are factors that would aggravate this case. First, I just want to acknowledge that the court obviously has heard that the victims not only lost their lives, but it affected the lives of all the people that were with them, children, friends, relatives. This is a ripple effect into the community that 3 people were killed in such a fashion. Nino Yang's mother was Pa Zilke. She passed away while this case was pending. Sadly, she had her own struggles in life. When the case first happened, she told friends of hers, people that she knew, that they shouldn't try to take justice in their own hands. They should trust the court system. From someone like her who didn't trust the court system very often, that was, I think, an honorable thing to do. Unfortunately, she put her trust in the court system, but for a lot of factors, this case took a long time to resolve, and she was unable to see the conclusion. But I think we should recognize that she initially indicated to people in the Hmong community that they should cooperate with the police, and without that statement, people like Michael Vang would not have come forward and ever talked to the police. So I think she deserves some credit for that, and sadly, she wasn't able to see the outcome. A couple of the aggravating factors are, first, the defendant's history. He doesn't come to this court without a history of not only criminal activity, but specifically gun violence. He's also had his probation or extended supervision revoked numerous times. In fact, he was on extended supervision when this offense happened. He had a possession of a firearm as a felon offense back in 2016, another felon possession of a firearm and reckless endangering safety in 2012. He had, going all the way back to 2006, an offense with a weapon and first degree recklessly endangering safety. So his violence and the use of weapons certainly aggravates the situation and sadly maybe predicts what ultimately happened. Wish we could go back in time and dig deeper into what was happening, but he certainly isn't new to using violence or firearms. Secondly, I think an aggravating factor is his complete lack of any remorse or emotion or empathy for the people that were killed. The PSI writer stated in his summary and conclusions that despite being found guilty of his crimes, Mr. Thao lacks any kind of remorse, empathy, or emotion. He continues to paint himself as a victim in the entire event. His thoughts only center around himself and his determination to be released. His offense was premeditated, violent, and showed a complete disregard for human life. And there are a few other points in the PSI where the lack of remorse is noted. I understand that the defendant exercises the right to remain silent, and he won't be punished for that. But at this point in this case, he's been convicted. The co-defendant's been convicted and is in prison. Been through 2 trials, and when it's time to talk to the probation officer who wrote the PSI, on page 4, when giving the defendant's version, it indicated that initially he gave his full description of the offense, one that was heavily inconsistent with the facts in the criminal complaint. After that, he expressed concern and possible regret about the information he had provided to this writer. His demeanor became hostile, and he demanded the full statement be deleted immediately. This doesn't square with somebody who cares about the people that were killed. It doesn't square with somebody who was innocent. He indicated in the last sentence of his version that Cam shot 3 people I consider family in the head, and I'm being charged for his actions. There are people that are affected by this crime that didn't even know these 3 victims, that are shocked at the brutality of it, that were shocked at the scene, that discovered the bodies. This community was scared that someone would happen like this in La Crosse County. The defendant, who claims to know the victims as family, helped run across the state with the co-defendants, helped try to hide information, hide evidence, hide a car. He was given counsel, given the right to remain silent, given a trial. But at this point, he still now can't even tell us what he thinks happened. That to me sounds like someone who's manipulative and trying to get away with something rather than somebody who was a victim in this circumstance. The court saw Bridget's emotion. I can tell you she's been like that throughout the case. Immediately after this happened, she went to the police and basically said, here's what happened. I can't believe what I saw. Mr. Thao at this point is still intimidating people, intimidating the probation officer that he's giving information to, and still not going to tell the court supposedly what else happened. At one point in the PSI, he speaks of the witness, and he says he feels he's not being treated fairly in comparison to others. He stated, quote, charge the fucking bitch, and quote, she has more to do with it than me. I think that tells you everything you know about Mr. Thao's character. The defendant doesn't have any known mental illness. At the time of this offense, it doesn't appear that he was acting in any way coerced into it, in any way forced to do it. In fact, just the opposite. It seems he was the one that was holding the gun and fired the fatal shots. The compass in the PSI is certainly not helpful to him. I'm not sure how much weight to put on that in a case like this, but I guess to the extent that it matters, it shows that he's definitely a high risk for the community. Given the facts of what happened in this case, and given the impact it's had on the community and all the people involved, and given the defendant's aggravating factors and lack of any mitigating factors, I think that justice and punishment would be the primary role in this sentencing, and I think life without any release is the appropriate outcome. Beyond that, I think the need for the protection of the public, as well as his character, also call for a no release option. The PSI recommends that they be concurrent to each other. I know it doesn't really matter, but I think they should be consecutive. I think each person deserves their own sentence apart from the others. As far as credit, I think the parties agree that if credit's to be granted, it's 1,223 days.
Yes.
And in terms of restitution, I gave Mr. Nelson a breakdown of this, but the total amount of restitution for the court is $12,076.02, an additional $1,207.60 to the DA's office. We'd ask that they be taken out of his inmate funds. And that's broken down further to Christine May in the amount of $1,835.94, to crime victim compensation in the amount of $5,000, and on behalf of Peng Lower to crime victim compensation for $5,240.08. And if that needs to be broken down further, we can give the court a copy after the sentencing. That's all I have, Your Honor.
Mr. Nelson?
Judge, I know Mr. Thao did prepare a statement. He'd like to read that. Does Your Honor prefer that he do that? I would prefer if he be given the opportunity to do that, and then I will speak afterwards, unless Your Honor has a different process.
Usually I have statements made at the very end by the defendants, but if he's willing to, any objection to him making the statement before the defense counsel?
No objection.
Go ahead if he wants to reverse it.
I didn't know Trevor that well. Would bump into him from time to time and catch up. Peng and Nemo, they were my little brothers. Two of them were very ambitious, especially when they're together. A lot can get done. We all came from different families, and we all had different problems. I once asked them why they are in the streets. Peng said he likes the lifestyle. Nemo, his mom was an addict, and to keep a good relationship with her, and to keep her happy, he made sure to feed her habits. Me, I couldn't go home. I didn't know where home was. The state wouldn't let me go home, and my family abandoned me. I was bound to survive in the streets. Started my own family. Peng and Nemo was part of that family. Together we pushed each other to be better, to stay strong, stay positive. When things were bad, I know what it feels like to lose someone you love. My mom passed away while I was in prison. After years of suffering and fighting, I came back to a broken home, then ordered not to go there. Because of them, I wasn't alone in the streets. It was hard to lead a good example for them. Sorry for being a bad brother and losing my brothers to the streets. For their families, I forgive every one of them for wrongfully judging me. Can you find it in your hearts to forgive me? I am not emotionless, and I'm a caring, loving man. Some would say sensitive or soft. Sometimes I wonder who I am in this world. And because of countless years of peering through time, I have fought to defeat my demons. Instead, I learned to live above them. From that, I run from both the living and the dead, haunted by those I could not protect. So as the world falls, each of us in our own way is broken and unique. It's hard to know who is more crazy, me or everyone else. As a broken person, I seeked help taking anger management, cognitive thinking, and AODA. Using the knowledge I learned, I'm being judged to be impaired and at risk for being patient, changing my beliefs, emotions, and controlling my behavior. Even labeled me a gang member, endangering my safety. And when I asked to take it off because of the danger, they asked, what gang you want to be? Is that justice or playing crazy? There are two sides to justice, truth, and they do as they want. This pattern shows the flaws in their system for justice.
Is that the end of
Okay.
As Your Honor knows, Galleon. As Your Honor knows, Galleon is the leading case that Your Honor, I'm sure, is very familiar with and will consider all of those factors. Certainly one of those factors is character. And much has been talked about Nya's character today. We're here because of his conviction, and the conviction is based upon behavior. I think one of the things we heard from Nya's sister family, as well as other families about the victims, is that, and I share this, that he can provide people with unconditional dignity, right? And that's what I'm here to do for Nya. My hope is that regardless of that, no one's condoning any behavior. We appreciate and understand he's been convicted, but nevertheless, he has dignity and respect, and I hope that that's what this process we can go through as professionals in a professional setting to continue to do that. And I think that that's an important part of this process today, not just at the end of the day. A lot of it comes down to a number, right? Unfortunately, this incredibly complicated, complex system and behaviors and everything, all too often I think it's oversimplified by thinking about it as a number. And I think the words that we all choose to use here in this setting are important and can give dignity to not just Nya, but to the victims, to everybody that's been involved, to appreciate the seriousness of not just what happened, but the seriousness of this setting. And so I say that because this is a mandatory life imprisonment sentence. The legislature, our lawmakers have said, this is life in prison. We're here essentially to talk about possibility of things by other people in the future. If we're going to focus on the number, we're obviously here to address lots of other things. I didn't mean to think that we're not addressing that, but when it comes to not your traditional sentencing where somebody's like, what's the result going to be? This is a mandatory life imprisonment. And I say that because I don't want anybody behind me, and I hope to convince the court as well that if there is a number that is provided as far as when he can request to be heard, that's not a number that in any way signifies an appreciation or a depreciation of the seriousness of this conviction. The legislature has said this is a Class A. It is as serious as it gets, and that petition number that we're going to discuss doesn't in any way, I think, show a greater appreciation for the seriousness of the crime if that number is larger or infinite, nor do I think a lesser number in any way depreciate the seriousness. I think at the end of the day, that's not the way that we should look at it as professionals here in this courtroom. That the entire process we've gone through, I don't know that there's been more process than this case. right? I mean, some of us have probably had cases that have had 2 trials before, but this is the only, had a couple of cases that have 2 trials, certainly never 2 trials that have added up to a total of 16 days. So if we're just talking about the process, that process right there talks about the seriousness and appreciation for the seriousness of not just what happened, but the seriousness of how we deal with this as a society and as professionals. So I don't want to get caught up in that number, but I need to address that number, right? I think the issues are his character. We've heard some of that. But we also heard from his sister that his mother, and we see this from the PSI, acknowledges that at his core, Nya Thao, at his core, like hopefully all of us, like I believe all of us, is redeemable, is someone that is loved. Despite this behavior, he can be loved. And I say that because I think that that's important for us all to recognize that there's a difference between what the sentence is here and whether or not Nya Thao is redeemable and can still has dignity. His family thinks that, and as we know from the PSI, there's been times where his family has been a victim of some of his behavior. But nevertheless, doesn't mean that they're asking him to be released. Doesn't mean that they're asking for a different number. But I think when you talk about character, that's what we talk about to some degree. And to be honest, I'm a bit surprised that in a case in which we all agree there was a brutal, horrific act that was done out at that quarry, that the focus today is on a remorse or a lack of remorse. Surprised about that. And the reason I'm surprised about that, and the reason I'm surprised, Judge, is because when we talk about character, Nya Thao does come from a good family, as his sister would say. As he says, his parents were kind, loving, and nurturing. But we also know, as he says in here, that he does have post-traumatic stress disorder, that he is bipolar, and that he is schizophrenic. That he has undoubtedly substance abuse issues. And so, for somebody with those conditions, we're still here to sentence him on the behavior, but to be surprised that he doesn't have the communication skills and or the awareness to appreciate everything when he's out on the street, essentially surviving. Day to day, he's trying to survive. And the criminal justice system, as Your Honor knows, and I'm not judging it, but does Your Honor, it's not a place that I think is easy for somebody with Mr. Thao's background and survival instincts to all of a sudden turn around and become vulnerable and speak to people in power in a way in which he is vulnerable. And that's essentially what we're asking. I think the hope is that he begins to make that progress. He begins to find those, hear that he is loved. He begins to hear these other things from his family and others, and that he can be appreciated, and that gives him the space to be vulnerable. But that hasn't happened yet. But that doesn't mean it won't happen. And the criminal justice system, in this short period of time that he's been involved since his arrest in July of 2021, it's been 1,223 days. But over a lifetime, that's a short period of time to make some of what I think the state's asking for is some sort of growth, some sort of awareness that he has the potential to do, but with the tools and where, with his limitations, perhaps due to some of the mental illnesses that don't diminish the crime, but talk about his character, right? I think that that's not a surprise. So I ask that Your Honor consider that in making your decision. the need, so we have character, we have the appreciation of the seriousness, which I think I talked about, and then we have the need to protect the public. As the legislature has said, this is going to be a life sentence. What Your Honor does have the potential to do is to put somebody in the future, right? The future is unknown, and it's my position that it's best to leave those in power in the future who will be in a better position than we are today to put them in a position to use their discretion in the future. If it's as obvious as what the state says, if it's as obvious as everything is in the PSI, then whomever that person is in the future that has that discretion to make that decision, it's going to continue to be obvious then. But we all know the future is unknown. And to give that person in power in the future the ability to use their discretion to, in many ways, trust in the criminal justice system. The state talked about the trust in the criminal justice system that was shown by the victim's family. And I ask you, as somebody who is a participant in the criminal justice, somebody that's a member of the criminal justice system, to show that same trust to the future people in our criminal justice system. There's whoever it is, they're going to get to that spot where Your Honor is in the same way that I imagine Your Honor got there. And I see no reason why we shouldn't trust that person to be in a position to use their discretion. And at that time, the answer is probably going to continue to be no, just like it's being asked for now. But why would we want to limit that, other than some sort of symbolism today? And I appreciate that, but is that really what the Galleon factors talk about when they say the need to protect the public? Because maybe in 25 years, that's different. Maybe in 30 years, that's different. Maybe in 35 years, that's different. We don't know, and it's impossible to predict, and all Your Honor would be doing is showing, I think, the humility that all of us should show, and that is that we don't know what the future is, and somebody else is going to be in that position, and you trust them in this system to use their discretion and the power wisely, just as the victim's family has said that we should all do. My other concern, judges, is that, as we know, we had a trial, right? There's 2 trials. And I don't think that there's anything unfortunate about the fact that there was 2 trials. That's just what the process took. And as Your Honor knows, at those trials, a huge part of the defense was who was the shooter. And I don't think we're here to litigate who was the shooter. I'm surprised that the state brought up the issue about who was the shooter, because a large part of part of the argument throughout the trial was it didn't matter who the shooter was. And if that's the truth, if it doesn't matter because he was charged as a party to a crime, and the principle of being a party to the crime is somebody who's a party to the crime is just as responsible as the person who is the shooter is, I wonder why the state makes the argument to undermine that today. I don't know that that's what the jury verdict says, but to be honest, I don't think that that's what we're here for. I don't think that that's what we're here for. If the law is you're just as guilty whether you're the party to the crime or whether you're a shooter, I'd simply ask Your Honor to honor that. Right? Because what I otherwise hear is that somebody who exercised their rights, and I think it was a reasonable exercise of those rights to have a trial. Because at the beginning, at the first trial, there was certainly 6 people that disagreed with the state's theory. That to me doesn't say that he went out on a whim and just had a trial because there's nothing that was to be contested. There was something to be contested, and we contested that, and eventually the state won. But I don't want it to be perceived, and I worry that if no number is given, a number higher than the co-defendant number, which was 35, if such a bigger number is given, that it is perceived as a trial penalty. And I don't think that's the message that anybody wants to send in La Crosse County, certainly not the court, that Mr. Thao has rights to due process. He exercised those rights, and now he stands here before the court having used those rights and having been convicted. But I worry about the silencing impact, the message that is being sent if there is such a sentence that treats Mr. Thao, who exercised those rights, different than the co-defendant perceive that Mr. Thao is suffering from a trial penalty. So for all those reasons, Your Honor, I ask that Your Honor do decide on a number, that you use your discretion to pick that number, that you consider what the number was for the co-defendant, but that you also use your words, use your knowledge, use your communication to let everybody know that that number doesn't impact or in any way depreciate the seriousness of this crime. The legislature's already decided that. That's not what we're here about today. What we're here about today is a good use of potential resources 30, 35 years out into the future when somebody else can decide what should we do now. And that's going to be more about what's needed to protect the future, what's needed to protect the public, whatever that time is, 30 years from now, 35 years from now, as opposed to today. And then to just end, Judge, again, I know kind of where we started, and that is Mr. Thao does come from a family that is, as he said, I want to make sure I get the quote correct, kind, loving, and nurturing, and even without such a family, everybody is redeemable, but certainly from that baseline, which we heard from his sister today, Mr. Thao is somebody that we should give dignity and is capable of redemption, and I would hope that Your Honor's words and ultimate sentence recognize that. Thank you.
Thank you. Mr. Thao, I usually ask after you make a statement, can I go ahead and sentence you at this point? Is it permissible that I go ahead and sentence you?
Yes.
So I do think this case is different from Mr. Botanisak's case, who is the co-defendant, and not because Mr. Thao had a trial, partially because Mr. Botanisak, he did take a plea agreement. There were some other aspects to that. He had somewhat of a different background. He has a big different background, and I'm not here to compare the two. I'm really here to look at what happened with Mr. Thao in this crime. First of all, I just want to start here. Families that lost these three people, Trevor Maloney, Peng Lor, Nemo Yang, I don't know how to say from the community, but our deep sorrow, even though it's years later that this has happened, is tragic. Should never have happened. And we saw during the trial, obviously, where they were, what happened to them when it happened. And not only is the court outraged, but I think the community is by it. I mean, there were, as I said last time, when I commented on this, it's hard to see this anything but a senseless execution over a minor amount of money. And it doesn't make any sense why human beings would do that to each other, Mr. Thao. We live in a society where we want to care about each other and love each other. And your sister expressed that well. It's about love. And love stops us from ever thinking that it's okay to point a gun at another person or let your co-defendant point a gun at another person and shoot them in the head as they kneel down, or even shooting anybody generally. So the gravity offense really overwhelms pretty much everything here. 3 human beings died senselessly over, doesn't matter what it was over. In fact was, it just seems even worse because the gravity offense is so senseless. It doesn't make any sense why something like this would happen. Now, the testimony during the trial, I think the court can consider the testimony at the trial. it was weighed by a jury, and the jury found that it was clear that you were directly involved as a party to a crime, what you did. You had the weapon at one point in time. And by the testimony of, frankly, Ms. Schlicht, is that you pulled the trigger and killed them all. I think they believed her. It doesn't really, I believe her, that what she testified to was the truth. And the moment, and when you look at the facts in the trial, the moment that's really sort of chilling is the idea that it was, I'm not going to use the word, but it was just basically F it, and you start shooting them. And that's got to be haunting as an individual to think that you did that. I mean, if you do have this compassion, this goodness, and actually the interesting thing is I think there was some testimony how you were not the one that people thought was as crazy as Blackie, as Mr. Ratanasek was. Which makes that action even more chilling, is that you just either, I don't think it's coercion, but I think you just sort of gave into the moment of, yeah, I'm just going to do this execution. I'm going to treat these people as something that are less important than all of us. So the gravity offense has really been a thing that has essentially weighed on the court's mind ever since the early part of this case, and then even more so now, because here I have to sentence you. And I agree with Mr. Nelson. The determination has already been done, is that you will serve your life in prison. The question is are you incarcerated the entire time, or is there a possibility in the future that some future people will make a decision that it's appropriate for you to be released? And I also think it's correct from the defense perspective, and I think he's right about saying we don't know what will happen between now and then. I don't know what you'll go through as you sit in prison, whether you really will make those changes or not, and whether those changes are significant enough that those future people would feel that it would be appropriate for you to be released. The one-way guarantee that would never happen is if I say life without the possibility of parole. The injury not only to the family but also the injury to the community is something I need to consider, and the effect on the community. I think it's pretty clear when this happened that a lot of folks are shocked that it happened in La Crosse County. Luckily, homicide generally doesn't happen very often, but this one was, in the history of homicides in our area, is pretty outrageous. I can't think historically there was one other situation before I even got here in the early 80s, which shook the community too. There is the pre-sentence investigation goes through your background as indicated. You have a long criminal history that's outlined. You went to prison, I believe, 4 times. That your supervision in the past was revoked. That from their perspective and the assessments they do, you're very, very high risk. That all makes sense. I mean, it all makes sense on the behavior that there was. And the court is supposed to consider under the Gallion factors not only your criminal history, but then your personality, character, and social traits. Even if, and I will, exclude that comment about the gang relationship. You're right, the suspect, I'm going to give any significant weight. I don't think there is a lot of weight there. The fact that you had guns and been convicted of possessing guns in the past, that's true too, whether it be a shotgun or otherwise. That's true. So, this idea that you came back from this, you come from this extremely traumatic background, which I think is why you have PTSD, probably is why you have bipolar disorder. It's somewhat related to this behavior, but you're actually 37 years old now. Why? Why did this continue to go on without getting the help that you needed? One, either the system failed, which is part of it. Two, is also you failed. You failed to follow through. You had a loving family that cared about you. And yet, you didn't reach out at that point where you realized, hey, I'm in deep. You yourself talk about your relationship with Peng and Nemo as being family. Who does that to their family? It doesn't make any sense. Trevor, unfortunately, is somebody who is there. One of the factors to consider is the vicious and aggravated nature of the crime, and I've already made some comment about that. I've already described it generally, but the idea that individuals go on their knees, you make them face away, clear out their pockets. Even if you were watching, Mr. Tatasek do this, you should have stopped it. And if you're the one doing it, which I believe is what really happened, you didn't take any consideration that these are three human beings in front of you. And two of them you thought were your brothers. I don't know if you can get any more vicious than that. Degree of culpability has been found. One of the factors, demeanor at trial, I don't think there's anything to be considered there. Quite honestly, I don't think that. I think you were neutral. You let the process happen, which is good. Your age, I already talked about your age. Also, I think the need for close rehabilitative control is obviously obvious because of the behavior that you have, the long-term behavior. Already talked about the public being sort of outraged by this. Long-time pretrial detention, part of that has to do with the fact that we had 2 trials on this. And then the last one, which I'm sort of letting is the remorse question. I don't totally disagree with Mr. Nelson that individuals suddenly will change their approach to this, and this is just generally correct. That people don't say, "Hey, I'm suddenly remorseful for this thing that happened." Some people do, but in this situation, that didn't happen. I don't think where you really get to remorse is the discussion with the probation agent. It's what's happened at the time of the crime, by the way, which shows that there was little to no remorse at all. The question, which I think is a legitimate question, is do we know in the future that there's absolutely no ability or possibility Mr. Thao would change his behavior and his outlook and his approach reason I'm pausing so much is because I'm trying to figure out how to say this to the community, to say, these are life sentences. But I do think a parole eligibility date should be established. It is a long parole eligibility date that I'm thinking is one that would put Mr. Thao as an old man before it would even be considered eligible for release. And the reason I think that's important is this. Because I think in every situation there's a possibility that things are going to change. The idea that there would be no ability to even consider this in the future, I don't think this crime, even though as horrendous as it is one where it makes sense to have absolutely no possibility. So I'll just say what the number I have in mind. It's going to be 50 years before I would even consider it. And that's not in consideration, just so it's clear. That is not in consideration of the fact that you took this to trial. It's consideration of the gravity of these offenses and sort of the background that you have of consistently always being in criminal trouble and not really making any significant change. It's going to take a significant amount of time before we should even consider this. Quite honestly, in 50 years, many of us will be long gone. But you're a young enough person that you will be an old man when they even first consider it. I should say this, older man. What I'm going to do is, I think it's on each count, you have life sentence with 50 years of parole eligibility. They will run concurrent to each other because otherwise it'd be meaningless. As far as the count 4, it'd be 4 years prison, 2 years incarceration, 2 years extended supervision. With the credit of that there is, it's almost time served, I believe. It's close to it. There's 1,223 days credit. The restitution will be ordered as outlined by the district attorney's office. If you want to give that list to the clerk, and that way we can make sure it's correctly put in the record. It'll be, is that joint and several?
Yes.
Okay, joint and several with Mr. Ratanasak. The payments will be made during the period of incarceration according to the policies of the Department of Corrections. There's also a 10% surcharge, if I didn't make that clear. The court's going to impose the costs, but vacate the cost of $518 because, quite frankly, I doubt it will ever be paid. And not only that, it's just not. I'd rather have the restitution paid if anything's paid. Obviously, he's not eligible for the challenge incarceration program, the substance abuse program. I just have to put that on the record. You'll continue on with the remainder of your sentence at this point in time. As said, you do have a right to appeal this. You have to appeal that within 20 days of today. Mr. Nelson would file the notice of intent to appeal. Before I ask if the parties have anything further, let me just ask one thing. Is there anything further on the sentencing, Mr. Grinke?
No.
Mr. Nelson. Before we move on, Mr. Thao, there is always a moment of hope for everybody. For you, it's going to be a long time in prison. lot of people here who want to need to be healed, and quite honestly, these sentencings don't heal anybody. It concludes things. I get that. But they really don't heal. The healing part, and this is for everybody else, starts when we all turn to each other and do it, interestingly, said by Mr. Thao's mother, which is love. And I say that because there is a lot of anger over something this horrible, but we have to move on somehow. None of us can easily heal, but none of us can easily be angry for the rest of our lives. So in memory of Trevor and Peng and Nemo, let's turn to each other as a community and look for that way to heal. Thank you, everyone.